Once again, on behalf of Calcutta University and the Department of Law, I welcome you to the second day of the Sir Ashutosh Law Lectures and the concluding day of what has been a week-long of cerebral retreat. May I request dignitaries to please take their seats on stage. With the head of the Department of Law and the Secretary of the Faculty Council accompanying Justice Ashutosh Mukherjee, Justice Sri Aniruddha Ghosh, Senior Advocate Sri Gopal Subramaniam, Justice Sri Aniruddha Ghosh on the stage. May I also invite the Pro VC Finance, Mrs. Momata Ray, Dr. I.G. Ahmed, to please take their seats on stage. Now present bouquets of flowers to the dignitaries. Please put your hands together for the Senior Advocate, Mr. Gopal Subramaniam. Please present the flowers. Justice Aniruddha Ghosh. Justice Ashutosh Mukherjee, Pro Vice Chancellor of Finance, Ms. Momata Ray, the Secretary of the Department of Law, Dr. S.S. Chatterjee, the Head of the Department of Law, Mrs. Shweti Chakraborty, Faculty Member and Professor of Law, Dr. I.G. Ahmed. Ladies and gentlemen, Sir Ashutosh Law Lectures, like we have been witnessing for the last one day, is one of the most prestigious, distinguished and peerless academic exercises of its own kind. May I call upon the Head of the Department of Law, Professor Shweti Chakraborty, to kindly deliver the welcome address.
Thank you, Paris, for calling me. A very good afternoon to everybody present on the dais and off the dais. Respected President of the session, Honorable Justice Aniruddha Ghosh, former Chief Justice of Bombay and Calcutta High Court, Ashutosh Mukherjee, Professor I.G. Ahmed, Dr. Gopal Subramaniam. He is the main orator of the lecture, and our senior professors, Professor I.G. Ahmed and Dr. Chatterjee, and our beloved Pro Vice Chancellor of Finance, and all the teachers of the various colleges, and our faculty members, Dr. Manirani Dasgupta, Dr. Das, and other honorable judges present here, staff of the university and our state officers, my dear students and the staff of the CU. I congratulate you all that today we are on the second day of the Sir Ashutosh lecture on separation of power, independence of judiciary and judicial accountability. Today is the second day of this most prestigious lecture series of Sir Ashutosh Law Lecture, which was created by governing body of University Law College in 1925 to perpetuate the memory of late Sir Ashutosh Mukherjee. It was only due to the efforts of Sir Ashutosh Mukherjee the University Law College began its journey in 1909. I feel pride to mention the names of some eminent jurists who have delivered the prestigious lectures. This prestigious lecture, the erudite minds were D.F. Mullah, Sir Tej Bahadur Sapru, Dr. S.C. Bagchi. Today we have Dr. Gopal Subramaniam, who is not only known by his designations like Senior Advocate, Supreme Court of India, former Solicitor General of India, former Chairman, Bar Council of India, but also by his great contribution to the real legal world. He has appeared in most important cases like Bombay Terrorist Attack case, Parliament Attack case, Union Carbide case, phone tapping of members of Parliament matter, and various other socio-legal and human rights issues. His contribution to the legal fraternity is notable. His effort to reform legal education is laudable, as Dr. Subramaniam has introduced All India Bar Examination. He was member of Justice J.S. Verma Committee on Amendments to Criminal Law. He has edited and contributed to the book Supreme but Not Infallible Essays in the Honor of Supreme Court of India, published by Oxford University Press. More or less, he is a member and advisor of more than 30 committees and commissions and academic councils at central level. I am privileged and honored to welcome Dr. Subramaniam to deliver Ashutosh Law Lecture. I am honored to welcome the legal acumen, former Chief Justice of West Bengal and Mumbai, Ashutosh Mukherjee, who needs no introduction on this auspicious day. He is the true guide and torchbearer for all generations of judges, advocates, teachers and students. He is omniscient, omnipresent and omnipotent. We have great reverence for him. Indeed, he protects us like umbrella. I welcome Sri Ashutosh Mukherjee from my core of the heart. Today we have with us our Honorable Justice Aniruddha Bose, who is the alumni of St. Xavier's and Surendranath Law College, Calcutta, enrolled with the Bar Council of West Bengal as advocate in October 1985. Practiced in original side as well as appellate side of the High Court at Calcutta in constitutional and civil matters, with a special emphasis on intellectual property law. And he was elevated to bench as permanent judge of the High Court at Calcutta on January 19, 2004. Honorable Mr. Justice, I do welcome Justice Aniruddha Bose from the core of my heart. Then we have got our Pro Vice Chancellor, Professor Mamata Ray. She graduated with first class in economics from Presidency College, Kolkata, did her MPhil and PhD in financial economics at University of Calcutta. She served Lady Brogan College and Presidency College as Professor of Economics for more than 2 decades. Presently interested in the area of human development and economics of education, served as Principal of Lady Brogan College and later as the First Lady Principal of Presidency College, Kolkata. Now she is presently holding the post of Pro Vice Chancellor, Business Affairs Finance of CU. She served as a member of consultative group of school education constituted by Planning Commission for preparation of mid-term appraisal of 11th 5-year plan, as member of MHRD Committee of Experts on Model Schools, and as a member of the working group on higher education for formulation of 12th 5-year plan. And she has acted as member of several NAC peer teams. She has contributed papers in journals and leading newspapers and has delivered many invited lectures. I feel privileged to welcome Professor Mamta Ray here in this department on this auspicious occasion. I also welcome our professors, senior professors, Professor I.G. Ahmad, Professor S.S. Chatterjee, who are always the guidance for us, and they are taking the responsibility of this department for a long time. So I do welcome from the bottom of my heart. I welcome Dr. Manihari Das Gupta. She is our associate professor and colleague. She is also a very active teacher in our department. I welcome Dr. J.K. Das, of my colleague, he is my colleague. And I welcome all the advocates and distinguished guests present here to this afternoon. And we hope that this will be a successful afternoon. After the discussion of Dr. Gopal Subramaniam, it will be followed by an interactive session. So I welcome you all to this afternoon of this session of Sir Ashutosh lecture. Thank you.
Thank you very much, Professor Chakraborty. The event is especially opportune given that we are in the centennial year of the birth anniversary of the foremost educationist of India, the very fearless Ashutosh Law. His role in starting the University College of Law was discussed yesterday. What is perhaps less known is that he transformed it from a center of learning into a center of practical learning and research. He was the first to institute a system of moot courts within the Law College in Calcutta, and the system until then was known only to colleges in England and primarily those attached to Harvard or Yale. I welcome now the senior advocate, Mr. Gopal Subramaniam, who, after a day of delivering a scintillating, splendid, and may I say spellbinding discussion, is back here with us, and we are fortunate to have him. Please put your hands together for Mr. Gopal.
Chief Justice Ashutosh Mukherjee, Justice Aniruddha Bose, Professor Mamta Ray, Dr. Sachi Chakraborty, Professor Ahmed, Justice Ganguly, and my very dear friends. Today we are going to actually walk a slightly more controversial area, and which is the area relating to judicial accountability and the independence of the judiciary. Yesterday, I set forth a proposition that separation of powers necessarily implies the existence of an independent judiciary, which is fearless, which is at arm's length from the executive, and which cannot be transgressed upon the legislature. I wish to begin with what ought to come at the end, logically, which is the introduction of the Constitution 120th Amendment Bill, but it's really the 99th Amendment Bill, and also the Judicial Appointments Commission Bill, 2013. I'm taking the firm stand that both these will emasculate an independent judiciary. I have serious reservations on the role of law ministers in the central government. To be a leading lawyer is certainly an advantage, but careful, scientific, and structured thinking needs more determination and objectivity. In the first place, we must look at appointments in the superior judiciary made in certain phases. The period 1950 to 1970 must be the first period. The records relating to appointments of judges should be neatly indexed and analyzed. This should consist of the judges of the Supreme Court and the High Courts during that period. The records will show how they were proposed and considered, and how the executive governments processed these proposals. While some judges have discharged functions impeccably, the same cannot be said of all judges appointed during that period. So in the first decade, we must be prepared to examine how many times the recommending authority went wrong. In fact, in my view, this needs a careful analysis of the official records which are still available with the central government. But one name comes to mind immediately, which is the subject matter of a reported judgment. A certain Chief Justice of the Madras High Court was charged with possession of assets disproportionate to his known sources of income. A case was filed against him by the CBI under the Prevention of Corruption Act. The Supreme Court entertained an appeal against the judgment of the Madras High Court, which provided that no FIR could be registered against a judge or a Chief Justice of the High Court or a judge of the Supreme Court without the sanction of the Chief Justice of India. The question was whether there was a requirement of sanction and who would be the sanctioning authority. What is important is that an argument was urged before the Supreme Court that there is no power of removal except under Article 124(4) and 5 of the Constitution. So it was suggested that there was no sanctioning authority which existed under the Prevention of Corruption Act. So the judge contended that the FIR should be quashed and it should be set aside. Justice Bankim Roy, who was one of the judges, held that it is farthest from our mind that a judge of the Supreme Court or that of the High Court will be immune from prosecution for criminal offences committed during the tenure of his office under the provisions of the Prevention of Corruption Act. Since Justice Veeraswamy ceased to be a Chief